As an Israeli litigator, when I have to deal with international disputes, I find myself thinking about a range of dispute resolution issues, which I'm sure you consider as well. Whether to prefer arbitration or court proceedings, if arbitration is selected, the significance of choosing a certain institution, rules, or venue, the identity of the arbitrator, how to obtain evidence from the other side, how to choose witnesses and experts, enforcement of judgments, and similar matters. And I've asked the panel members to consider these issues. And I would like to start with Ben. I would like to hear your views on the question of whether arbitration or courts are the preferable forum for resolving commercial disputes. And please consider factors such as efficiency, reliability, enforcement, and the like.
Thank you very much. When clients come to a dispute lawyer like myself, and they ask whether to arbitrate or litigate a dispute, unfortunately, the fact is they've probably, in a lot of cases, already committed themselves to one or the other. If it is arbitration, there will be an arbitration agreement, often in international contracts. And then you are presented with a reality that you need to make the best out of. I'm going to be slightly controversial today, and I know I've got a very preeminent arbitrator right next to me, but my working hypothesis is that you should probably never arbitrate unless you have a very good reason to do so. And of course, the question always is, if you're saying, should I arbitrate or not, what is the alternative? And I'm here not as a UK trade representative. I'm Israeli born, German raised, working in England now. But I can tell you that if the alternative to arbitration is litigation in the English courts, I would always, unless again there is an excellent reason to do otherwise, recommend litigation in England. And if the parties can agree on English law as the governing law of their agreement or any disputes, then better so. And I'll tell you why I'm saying that. A recent example is an international manufacturer of consumer goods with distribution agreements all over the world with local distributors. Comes to me and says, a local distributor has outstanding invoices in the sum of $500,000 or thereabouts. And I say, well, please show me your agreement. And the agreement says, ad hoc arbitration, subject to UK law. I said to him, do you know what UK law is? I know what English law is. I know what Scottish law is. I don't know what UK law is. Maybe you will enlighten me. It was actually an American in-house counsel, with all due respect to our American friends. And all we knew was that there were 3 arbitrators to preside over the arbitration, unknown identity, to resolve that dispute. And there was no way of getting out of it. Now, if you have a dispute involving parties from 3 or 2 different jurisdictions trying to agree on the identity of the arbitrators, already gives rise to all sorts of problems, not least logistical, which then has an impact on the costs that you will have to spend in order to empanel a tribunal to look at the issues that you're trying to resolve. And it creates a headache that you would not have had otherwise. Could you just go and serve either a statutory demand or issue a plain vanilla claim in the English High Court? So why do you create a headache for yourself by overcomplicating something that could be much easier, thinking that arbitration is the right forum? Now, I'm asking, is there a confidentiality issue? There isn't. Is there an IP issue? And I've had the benefit of looking at Neil's notes before. I know he's going to be talking about IP in a minute. Is there an issue of intellectual property? No, there isn't. It's a plain vanilla dispute. I have delivered goods that you have ordered. You have not paid your bills. Please, can I have my money? And we're now having to find 3 arbitrators to find a location, to find convenient times, and so on and so forth. And it can take up to a year, sometimes more, to get to a hearing. And then you get into the whole enforcement issues that we'll touch on later as well. So what I'm trying to say is, again, as someone who practices law in England, and other people practice in other jurisdictions, they can praise the virtues of their systems. I say to my clients, if you're happy to agree on English law and procedure, you can pretty much bet your mortgage on it that you will get a highly competent High Court judge who has practiced law for at least 25 to 30 years before being called to the bench. You will get a fair trial. You will get all the benefits of the common law system, and those benefits come at a price as well. If you compare the common law system to litigation on the continent with the civil law system, and you don't have the disclosure obligations in the same way that you face in the English courts, although that's changing now as well, then you can be pretty damn sure that if you're owed that money, you will get that money at the end of the road. And I think I've briefly chatted with Neil before. Often arbitration practices will say, well, the speed which you get to your answer is something that speaks for arbitration. I think in reality, especially when you deal with an ad hoc arbitration, which is not governed by institutional rules, you find yourself with endless extensions because really the arbitrators don't want to piss off the parties that pay them, which is not something that High Court judges care about, and they're just less strict in enforcing and penalizing bad behavior. Talking about costs also, of course, the arbitrators are a profit center. They want to generate money out of that if they are professional arbitrators. It creates an inherent sort of tension between the desire to provide a good customer service and to do what is necessary under the procedural law so as to not to expose yourself. On the other hand, of course, delays, multiple hearings, iterations and reiterations of correspondence is something that is not necessarily not in the interest of somebody who charges by the hour. And lawyers. If you come to the London market and you ask a big London firm, what are your litigation rates and what are your arbitration rates, you will often find that there is a miraculous 20% uplift, which is, often explained to you by reference to the complexity of the arbitration procedure and the requirement for an expert in that field. And again, with all due respect to those who specialize and who practice arbitration every day, if you know how to read and you're a lawyer, you are pretty certain to be able to figure out what the rules are. And we have the concept of barristers in England. And as a solicitor, one is always reassured by the fact that there is someone who knows better and can give you a second opinion. So if you ever get hung up on procedure issues, you can always bring in someone else to help you, even though I'm not sure in 99% of the cases, it is necessary. Now, the one big advantage arbitration has that is often cited, and which I fully agree with, is enforceability. And I think Neil has a slide on that as well, a pretty one, about the New York Convention. So that makes enforcement easier, perhaps, than, say, an English court judgment or an American or an Israeli court judgment. But I've been threatened with frustration of enforcement, irrespective of the New York Convention, on the basis that the other party said that even if the arbitrators find on a particular point of their local law, which they do not agree with, they will make applications to the local court trying to frustrate enforcement under the New York Convention. So again, it is not your silver bullet necessarily. And finally, my final point, I think we're running out of time, is your ability to appeal a bad decision is more limited than if you were in the English courts. And that makes it difficult in situations where you have only very limited control over who at least one or two of your arbitral panel is or are, which in the High Court there are checks and balances historically that have evolved over time, which pretty much guarantee that the judge that you're getting will give you a decision that is not totally absurd, and yet if you disagree with it for good reasons, you have, again, a solid and reliable route to appeal. So Neil might violently disagree, and I'll hand over to him.
Okay, Neil, now it's your turn. I would like Neil to deal with the issue of IP and technology matters, and in particular whether arbitration works for IP and technology disputes. And I would like you to react to the provocative view raised by Ben, who says no to arbitration.
I'll very happily do so. So in the next 10 minutes, I'm now going to prove, eruditely though it was argued, exactly why Ben is entirely wrong in everything he's just said, but only in the context of technology disputes. So I'm not a great fan of statistics. I come from the view that subscribes that statistics should be viewed as the drunk views a lamppost, which is more for support than illumination. But nevertheless, I've given you two surveys which I'm going to run through, which I think are quite interesting, which look at the technology, media and telecom sector. The first is a survey carried out by Queen Mary University London, and it looks at the types of disputes in this sector, and to what extent those disputes, when the panelists were asked, should be litigated or arbitrated. There are about 400 questionnaires and about 70 personal interviews, and the aim was really to look at the stakeholders' perspective of the use of international arbitration in the context of technology disputes. So the findings said that 92% of the people actually really wanted to arbitrate technology disputes. The trouble was, if you look down the list, is that not many actually are. In terms of the actual finding, in this sector, which lags behind everywhere else, only about 50% of people litigated and only about 27% arbitrated. So there's still a big gap between the range of actors in terms of people who want to arbitrate this type of dispute, but still fall back towards litigating. So I won't do the other points on that slide. We'll pick them up as we'll go through. But the other survey was quite interesting, and this addresses what Ben went through to a degree. This next section, which I want to go through, is this is the Global and Technology Dispute Resolution Center and the Silicon Valley Arbitration and Mediation Center. And what they did was they interviewed all their members and they said, what are the three biggest problems with litigating our technology disputes? And you can see the three biggest were cost, time to resolution, and inexperienced and unqualified judges. And then the top three benefits of arbitration were, conversely, specialized expert decision-making, time to resolution, and increased privacy and confidentiality. Now, I think that's quite interesting because I entirely disagree with that. If you look at, in my view, the most convenient and interesting thing in the context of international disputes for using arbitration, it's much further down the list. It's 6, multinational enforcement of awards, and 8, optional arbitral appellate procedures. I think those are far more generally regarded by the international arbitration community as the key reasons for the advantages of arbitration over litigation. And it's interesting that in the sort of IP technology center, that isn't necessarily picked up as a thought process as you go through. So if you look at this list on this next slide, these are the usual reasons that are thrown out by international arbitrators as good reasons why you should prefer arbitration in a dispute over litigation. Procedural flexibility, neutrality of forum. So for the last 6 years, I've been litigating between Israel and Egypt over the gas supply disputes. Now, there's no conceivable way at the time that those contracts were struck that either Egypt or Israel was going to agree to resolve its disputes in their own national forums. So they had to pick some means of doing so. Arbitration was chosen, English law was chosen, even though England had nothing to do, of course, with the supply contracts between the two countries, but due to precedent or otherwise and the need for a neutral system. And in essence, those disputes ran all the way through. They were able to litigate, to arbitrate all the way through to a final determination in an arbitration hearing held in Paris. So if you try and resolve cross-border international disputes in that context, and you try and do that at a national litigation level, it's never going to work. So unfortunately, as the internationalization of supply increases and improves, as Israeli companies spread further and further out into the world and are selling their businesses elsewhere, you are not going to be able to rely upon litigation, and you're not necessarily going to want to litigate in the national courts of your customers or otherwise. So arbitration has to become part of the dispute resolution portfolio to deal with the resolution of those disputes. I said I'd talk about finality and enforceability. This is from an English context, but you could do exactly the same process if you applied it to your own country. So if you look here at this chart here, these are the countries that are coloured are the only countries with which England has a reciprocal enforcement judgment convention. So if I go to the courts and I get a judgment, and I want to take that judgment worldwide, and I want to enforce it elsewhere, it is only those coloured countries who will respect and look at that judgment without me having to relitigate or try and rework that judgment in those other countries. Look, however, at the New York Convention for Enforcement of Arbitral Awards. It's only the red countries, a little band in East Africa, that the remaining countries, 157 other countries in the world, agree to take the arbitral award and enforce it as if it was a domestic award of that country. So that power, that ability to take that arbitral award and take it internationally is hugely important. The other factor I talked about was finality. Arbitrability is a bit of an issue in the IP and technology sector. I raise it just because I wanted to raise one point in relation to it. Not everything can be arbitrated. So in the technology sector, one of the things that's been holding back arbitration is the fact that if you get to a dispute, you can have a dispute between parties as to rights arising under IP rights or otherwise. That's inter-party. You can get an arbitral award, and that will affect the position as between those two parties to the contract. The difficulty comes, of course, if you want to apply that in a wider context against third parties who are not party to that arbitral dispute. So the general thing that's been holding the issues back is to the extent to which rights are granted or are governed by or regulated by a particular national organization or otherwise, then some of those disputes can't be arbitrated. And that's one of the things I think has been holding back this technology sector or otherwise, that not everything can be arbitrated and some things have to be litigated. So in summary, contrary to the usually turned out views, and this picks up something that Ben was saying earlier, for me, flexible procedures, specialist arbitrators, neutral forums, finality, you can choose in arbitration not to have an appeal. So you can exclude certain rights. There's not everything you can exclude, but most rights of appeal under most jurisdictions you can exclude. So you can get that finality, so you're not stuck into a court process that appeals for years and years. And confidentiality, as long as you want it to be confidential. The biggest mistake made with arbitration, of course, is everyone assumes it's confidential, but in most jurisdictions it's not, unless you specify it to be the case. I disagree with the view that most people say that it's cheaper and quicker to arbitrate. It's not anymore. It generally takes longer and it's more expensive. Those aren't really the good rules for arbitrating. And there are problems with arbitration. We've talked about arbitrability. There's also the problem with multiple party. So joinder is always difficult where you have multiple parties, unless you've got party consent. And there's also the issue that I don't think, and I agree with Ben's comment, in relation to emergency measures or interim measures, arbitrators, although they say they are, they're still not strong enough in dealing with that compared to a judge who's very happy to sort of wade in at an early stage of dispute and try and cut through a dispute. So, KISS, I call the next slide. If you want to go for an arbitration clause to avoid the problems Ben says, just keep it short and simple. Those are the issues you need to deal with. I think probably the two that annoy me the most, if I have to explain to commercial clients one more time the difference between the seat and the location of an arbitration, I'll go mad. If you want to go to the Seychelles, that's absolutely fantastic. You can choose that as your location. It'll be sunny. It'll be lovely. You'll get a nice tan. In my case, I'll go red and peel. But for the majority. But the trouble is, as soon as you get a procedural law question, that's the end of you, because the seat governs the procedural law of the dispute, not where you sit and enjoy the arbitration. So if we could educate more people to that, that would make life a lot easier for the majority of us. The other thing is choice of laws. Very quickly, there is a proliferation of applicable law in arbitration. So if you've got a governing law of the contract, that may be different if you choose a different seat or place, which governs your procedural law. You'll also have a separate governing law potentially of the arbitration agreement, and you'll also end up potentially, if you try and enforce it, with a different law as well in the place of enforcement. So unlike national courts, that is an issue. There is a proliferation of laws. And finally, there's a proliferation of places you can go. But I think that's a good thing. So unlike courts, where you're stuck with Mr. Grumpy Old Judge and one person, here you can go and shop, and all of these organizations fight against each other for the business. So if you think a particular arbitral institution is doing better in a particular industry sector, then go choose it. Persuade your clients to use it. That'll make the others up their game and make for a better purpose. So all in all, that's why I think ultimately, particularly in this sector, arbitration is lagging behind, but it shouldn't be, and you shouldn't follow Ben and just go to court, because arbitration can solve your dispute very well for you.
Thank you. Ram, I would like you to tackle the same issue from an Israeli angle, from an Israeli perspective. And please consider applicable law, as well as costs, enforcement, and other considerations.
Okay, thank you. Well, the question of whether we go to arbitration or court, and whether we do it here in Israel or we litigate abroad, has a somewhat negative connotation to it. It's also known as forum shopping. But as long as we apply legitimate considerations to it, it's not at all negative. We're trying to see where the advantages or disadvantages are. And what I would try to begin with is, well, relate to something which was said here, and that it's almost always the case in which there's, in case there's a contract, there's a foreign jurisdiction clause which refers us to jurisdiction, and you will say, well, look at what the contract says, and if it says arbitration, then arbitration. If it says foreign jurisdiction, then that's it. But according to Israeli law, Israeli Supreme Court held in a number of cases that in order for a foreign jurisdiction clause to apply, the language has to be explicit. It has to say that it has to be exclusive. It has to say that only this forum will have jurisdiction. Otherwise, it could be interpreted as a parallel jurisdiction clause. And in such a situation, you can decide whether to go to an Israeli court and litigate, or whether to go to a foreign jurisdiction court and litigate there. Now, what is interesting is that is the same also with arbitration clauses, foreign arbitration clauses. And there's some sort of an anomaly here, because when we're dealing with a contract between two Israeli parties that decide in the contract to refer the matter to arbitration, Israeli court will interpret it as a simple matter of contractual law, and we look at what is the language, what did the parties intended, and so on. But when there's a foreign arbitration clause, Israeli court will apply the same interpretation rules as it applies to foreign jurisdiction clauses. So it has, again, it has to be explicit. It has to say the wording can't be soft. It has to say that it is exclusive and so on. And these are situations in which there is a clause in a contract, and there is a contract. And we have other situations in which there is no contract, and there different jurisdictions apply different set of rules in order to acquire a jurisdiction. Some apply what are known as personal links. This is also true for Israel. Israel courts apply what is known as a link, which is a service of process, which means that if the party is here in Israel, even for a brief moment, you can file a claim against him. Other jurisdictions apply links relating to the subject matter, meaning that if an asset is abroad, then you can file the claim to where the asset is. So there can be a conflict, and again, we have room to maneuver, and we can file the case here or there. As for considerations, I think that the first thing to look at is the applicable law. If the applicable law, the substantive applicable law, grants our client with an advantage, then we will probably try to litigate it in the forum, in the jurisdiction in which the governing law refers to. However, if there is some disadvantage to the client, there are things that we can do. First of all, we need to look at the matter of classification, the difference between substantial matters of law and procedural matters of law. And different jurisdictions look at this matter differently. Some jurisdictions look at matters of statute of limitation as a procedural matter. Others look at it as a substantial matter. Evidence law. If we apply Israeli evidence law, even if there's a clause in a contract saying, for example, that German law will govern the dispute, okay? And we decide to litigate it here in Israel. The procedural law will be Israeli law. German law, we will need to prove, as any other fact in the case, we will need to bring an expert opinion to explain to us what German law says. But let's talk about how we present evidence. Israeli procedural law regarding evidence or regarding discovery, for example, is more flexible than other jurisdictions. If we do not disclose a document, then maybe we will be regarded as not acting in good faith. There's a presumption that this document acts against us. We will not be able to present the document. But in other jurisdictions, as in the US, for example, if you do not disclose a document, that could be the end of the case. So I'm not saying go litigate in Israel because you cannot disclose documents, but that's something that you need to bear in mind. As for arbitration enforceability of arbitration ruling, in Israel it is, and in other countries, as was already presented here, it is governed by conventions. And there's a question of whether or not Israel and that other jurisdictions are party to a convention. Israeli courts will enforce foreign judgments or foreign arbitral ruling provided that there is a reciprocity between Israel and that other judicial system. However, in Israel, it is enough that there is a potential for reciprocity. So even if there's no convention, you can also enforce the foreign judgment or foreign arbitral ruling here in Israel, and there was recently a case in which a Chinese judgment was enforced here in Israel, even though there's no convention. And as for other considerations to be looked at when you try to decide whether to litigate abroad or in Israel, you mentioned earlier, both of you mentioned the issue of the time and the issue of costs. Well, that depends again of the position of the client, because in Israel the courts are packed. Israeli judicial system is not very fast. It can take you between 2 to 4 years to litigate a case in the district court, and this is, I'm saying it in favor of the judicial system, 2 to 4 years. In the Supreme Court, it can take at least a year more, sometimes 2. And if you're looking for the fast track, maybe litigate abroad. If you're, on the other hand, representing a defendant who wants to stall time, then maybe Israel is the place for you. As for costs, once again, if you represent a client that has resources, he will probably want to try and transfer the litigation process abroad, because litigation in Israel is relatively cheap, relatively, if I compare it to the UK and to the US.
The same, but in shekels.
The same, but in shekels, in a good situation. But I'm not only talking about fees paid to lawyers. I'm also talking about the unwillingness of the Israeli courts to award actual fees. When a party in Israel loses a case, and it's only in rare occasions that the court will award actual fees. Normally, the court will award only minimal fees, and that's even in a case in which the party has resources and it's a commercial party and so on. That's because of the notion that you need to keep the doors of the court open for everybody and so on. We have the same conflict in Israel of whether to go to arbitration or maintain the case in court. Same considerations. Sometimes arbitration can be faster. Sometimes arbitration can be cheaper, because in Israel there's no, you usually don't pay a fee in order to file the claim. But then again, when we look at whether or not to litigate in Israel, and I'm going to finish at that, whether or not to litigate in Israel or litigate it abroad, I think that apart from looking at the other considerations which were mentioned here, I think that the applicable law will probably be the most relevant one.
Thank you. Mark, first I would like to hear your views on two concepts, concepts which are less familiar for Israeli audience. The first one is class arbitrations. The second one is investment treaty arbitrations. And I also would like to hear your views on the suitable rules. I understand that you are quite familiar with ICC, ICDR, UNCITRAL, and so on. And can you give us some advice on the issue of which of the rules are best suited in which contexts?
Sure, there's a lot of ground to cover, but I'll be happy. I'll be happy to do
Okay, you
that.
have 10 minutes.
But even before, okay, well, 10 minutes is more than enough. But before we do that, I want to get into this fight between Ben and Neil a little bit, and just say that I think we have to take a middle way. And the middle way is that I think even though many of us here are arbitration practitioners, or at least some of us, we have to be a little bit agnostic about arbitration. So where I think Ben has the argument is that arbitrators sometimes can get it wrong. And then you don't have a means of really dealing with that because the state court review is quite limited. I think where Neil has it is that enforcement really is the key thing. And Neil talked a little bit about technology and arbitration disputes, and our firm does a lot of technology work, but the tech companies have been slow to adopt arbitration for a variety of reasons, although there are many reasons that would commend it. What I would say to Israeli companies dealing with a U.S. counterparty that insists on U.S. litigation is that you point out the fact that if they win, their judgment is not going to be easily enforceable because unlike the very interesting map that was shown regarding where an English judgment can be enforced, it's actually, compared to the U.S., it's quite good because there are no reciprocal agreements between the U.S. and any other jurisdiction that provide for the enforcement of U.S. judgments, and we know why. It's just for the very reasons that everybody in this room doesn't want to be in the U.S. courts because of the perceived problems, you know, the jury system, punitive damages, discovery sanctions. So arbitration really is the way to go. And for me, arbitration really almost becomes the default international court. Why? Because you don't want to be in the other guy's courts, and they sure as heck don't want to be in your courts if you're an American. So you find another institution that really plays that role. Is it a perfect institution? No, it's not. Do arbitrators sometimes get it wrong? Yes, they do, but there are problems with the court system as well. One approach, if you're really trying to maximize both, is that you could provide for arbitration under the Arbitration Act 1996 in London and maintain reviews on questions of law. So you can have a hybrid system. You have that in some arbitral institutions as well, but that actually is provided for in the law in England. So that's something to think about. So let me seg now to talking about something else, which has to do with an issue that one of our speakers talked about from the very interesting talk from the Israeli Innovation Authority. What happens when we're dealing with emerging companies and some of their business models start to collide with state regulatory systems? And then how does that relate to international dispute resolution? Many emerging companies attract a higher degree of regulatory risk because regulators view their models, often rightly, as quite disruptive to social patterns, disruptive to the economy, disruptive to established ways of doing business. And we know that there are entrenched interests that can be harmed by some of these new business models, and we know that they do create disruption without necessarily having a lot of physical presence in the jurisdiction. And we know also that some tech companies, sure, certainly not all of them, but some can be rather disdainful of regulation or at least affect that attitude. The companies themselves view what they're providing as a social good and see regulation as something that is really interfering with their business model and the service they're trying to provide. Moreover, despite what I said about arbitration, where you have many tech companies insisting on courts in a parochial way, they view their business models almost as transnational or a-national. So what we're seeing now is a response by many state regulators that's really destroying this idea that we're in some kind of post-Westphalian world where nation states don't matter anymore when it comes to tech. They're trying to control these tech models. They're trying to control them in order to sometimes deliberately protect local interests, sometimes to enhance their revenues, to capture what they view as lost revenues, and in other cases for other objectives, and sometimes these regulations can be arbitrary and disruptive. So for instance, in tax, we have a movement away from a permanent establishment test to something that's looking at capturing diverted profits, as we have in the UK, or an equalization tax based on ad revenue in India, or in France, where we're now collecting tax on the basis of user data that's collected. Some search engines or platforms are now being used or seen as almost essential facilities or common carriers. That's a discussion that's now being had in many regulatory circles about regulation of platforms like Google and Facebook. Privacy issues, that's a world unto itself. Who owns the data? Are these apps actually products and subject to product regulation? Are Uber drivers or ride-sharing drivers, are they actually employees or are they independent contractors? All of these issues are emerging and they're all being addressed by regulators. So how does a disruptive business model deal with regulation, especially when it goes beyond reasonableness and is arbitrary and even protectionist in its approach? There is a body of law above national law. It's called international investment law. It's not national law. It's something apart from that, and it governs the duty of states toward foreign investors, and it provides for certain standards of treatment. The states can provide higher protections through the agreement, but there are also standards of treatment under international law. And as of the 1950s, there's a particular kind of treaty that gives foreign investors the right to bring a direct action against the state, and here's where it comes to intersect with arbitration, through international arbitration. How many people have heard about this? Okay, 1, 2, 3. Okay, some. So there are about 3,000 of these treaties, at least the bilateral treaties, and it's estimated they cover 2/3 of all foreign direct investment. Like arbitration awards in the commercial sector that are enforceable under something called the New York Convention, many of these awards are enforceable under something called the Washington Convention, which is even more restrictive in terms of local court appeal resort. These are actually supranational awards, and every 153 members to the Washington Convention have to enforce these awards as if they were local judgments. Now, that doesn't mean that every tech company is going to run out and start an arbitration with a state because of some unfair regulation. And it doesn't mean that every tech company is necessarily going to say that this is a first order of priority for them. But it does give these tech companies arguments they can make, and it allows them to articulate these rights in the face of arbitrary regulation. Here are some of the broad standards that these treaties provide for. They're very general. Fair and equitable treatment probably being the most important one. Expropriation must be followed by prompt, adequate, and effective compensation. National treatment means you have to treat the foreigner just as well as you treat the local. Full protection and security means you can't let the warehouse burn down when the fire squad is right outside just watching it happen. However, you have to use these treaties, you have to be a national of that state that has the treaty, of that nation state that has the treaty. You can be a shareholder, but you have to be an investor or have an investment. Neil talked a little bit about IP. Many of these treaties directly extend to IP, to patents, and to trademarks if they're exploited. And even where they don't, at least one decision has now ruled that trademarks are included within the definition of investment. Now, if there's not a treaty in force, you may be able to find a jurisdiction in which to incorporate in order to take advantage of this mechanism. This would be true for funds coming into Israel, where they want protection from Israeli adverse regulation, and it would be true for Israeli capital or companies going outbound as well. Israel has about 38 of these agreements in effect, notably China, Cyprus, Korea, India, France, and Japan, and a host of others, some of which may not be as economically important as others. There's also at least one free trade agreement with an investment chapter with Colombia. And Israel's a party to that convention I mentioned a moment ago, the Washington Convention. Cyprus, I know, is interesting. I know that the Cypriot approach to incorporation and uses of an offshore in Israel is changing and becoming stricter, but where there is a substantial investment, it could make sense to structure, and I think this is something that firms should have in mind. This isn't a cure-all, but it gives investors rights, and it's something you should think about when you're structuring investment and before you have a regulatory dispute. Now, I think class arbitrations was the other thing you asked about. I think about 10 or 15 years ago in the United States, there was a lot of interest in the idea of having class arbitrations. We have class actions, why can't we have class arbitrations? And many arbitrators started to rule that under some arbitration clauses, they had the right to aggregate claims. Well, these cases now have been up and back to the Supreme Court for the last decade and a half. And the bad news for class action plaintiffs is that the door, although not completely closed, is closing if it's not almost entirely closed. Most recently, the Supreme Court ruled that even where the California courts had ruled as a matter of state law that a waiver of class actions was unenforceable because it was unconscionable, that was preempted by the federal law in the U.S. on arbitration called the Federal Arbitration Act. I suppose if you had a clause that affirmatively provided for class actions, you could then have class actions, and indeed the AAA, the American Arbitration Association, does have class action rules. But the idea that a clause that's either silent on class actions or that specifically waives resort to aggregation of claims would be enforceable, I think, is very unlikely. Whether this was the right move on the part of the defense bar in the United States is another question, because you could think that, well, if we're going to have classes, why not at least have them in arbitration? But they've taken the approach that they don't want to have them at all. I think you asked me one more question.
But I think that...
that's the time is up. Okay.
Time is up.
Okay.
So, Juan, I would like to hear your views on the various topics we have just discussed, and especially on enforcement of awards in international arbitrations.
Okay, thank you, Jill. The good thing to be the last one speaking is that the real important things has already been said. So we can just focus on more trivial things. I am almost sure that everybody in this room has a mobile phone, either Apple, iPhone, Samsung, LG, whatever brand. Yesterday in Barcelona was the opening of the World Mobile Congress that bring together all these manufacturers and the software developers to the city for 1 week. Can you make a guess of which is the dispute resolution method that all these companies have chosen if anything happens during this week for IP, trademark, patents, any dispute between these companies? It's not arbitration. it's the court. And the commercial courts of Barcelona have signed a special agreement and protocol with the Mobile Congress to solve any dispute between these companies in 48 hours. So this is not the real life. Maybe, but it's not. Yeah, including siesta, right? What is the reality in the Spain, on the Spanish judicial system? And what we recommend to clients when they do business in Spain. It's not the 48 hours rule, but just a few data. In 2016, there was 1.8 million civil cases into the courts. Of these 1.8 million, only 500,000 were solved by judicial decisions. So there is a big number of pending cases before the Spanish courts. And when you have the court decision, you have to enforce if the parties voluntarily does not implement the decision. So at the end of 2016, there was almost 2 million cases pending to be enforced. So this is a total disaster for a client. After having been between 8 months and a year and a half in first instance to reach or to get a decision, then you have to wait for enforcing this. So this is one of the main reasons why we recommend, especially to foreign investment and to foreign clients, to focus on arbitration much better than in courts. When the courts have resources, as they have now in the Mobile Congress, it's perfect. But this is not the rule. Maybe, and I was quite surprised to realize the number of lawyers there are in Israel per inhabitants. And I thought in Spain the competition was quite strict because we are one lawyer for every 182 people. But here in Israel is one lawyer for 114 people. So you have even to compete much more than us. And this is one of the reasons why the judges say that the judicial system in Spain is so collapsed, because there are too many lawyers trying to bring cases for it. Why, regarding the enforcement that you mentioned, Jill, in Spain there is a two-step process to enforce an arbitration award. First, you need to recognize the arbitration award, the foreign arbitration award, and then afterwards you have to enforce it. It's two separate proceedings. The first one in front of the Superior Court, and it takes between 3 to 5 months. And the second, the enforcement, is in front of the first instant court. It takes around 2 to 8 months, depending on how complicated it is to enforce it. But the reality about people challenging the recognition of awards is very few. We have, in the last 3 years, only 20 cases that defendants have challenged the arbitration award, the recognition of foreign arbitration award. Of these 20 cases, only 2 were successful. The other 18 cases were dismissed, and the court recognized the arbitration award. And these 2 cases that were dismissed, one was because the arbitration award was suspended in origin in Quebec, and the other one because it was a commercial court decision of Kiev in Ukraine. It was not even an arbitration award. But the reality shows that the Spanish courts are quite positive in recognition the arbitration award. 2 points that you were mentioning, this is my last word. Okay, we don't have discovery in Spain, and we don't have either punitive damages. And this could be shocking for the American, the US lawyers. Discovery is something that we can benefit from arbitration. We can apply rules that allows the discovery. And punitive damages, until last year, was totally prohibited under Spanish law. Last year, there was a Supreme Court decision that is opening the door to recognize punitive damages as far as 3 different tests are passed. I can explain that on the break if you want.
I would like to thank Ben, Neil, Ram, Mark, and Juan, and you. And thank you, and good evening.